Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut. And today what I'm going to talk about is how to attempt to reopen a judgment after a divorce or custody case is finalized. So that means after you enter into a divorce or custody agreement, or if there is no agreement and you had a trial, it means trying to reopen the case after the judge issued his or her decision. So getting right into it, I'm going to share with you the relevant statutes and case law. So the first statute we're going to look at is 52-212. And that says that any judgment, so this talks about opening a judgment upon default or non-suit. So basically when the other side doesn't show up or doesn't participate in the case at all, really. They don't file an appearance. So it says that any judgment rendered or decree passed upon a default or non-suit in the Superior Court may be set aside within 4 months following the date on which the notice of judgment or decree was sent. Upon the complaint or written motion of any party or person prejudiced thereby showing reasonable cause, or that a good cause of action or defense in whole or in part existed at the time of the rendition of the judgment or the passage of the decree, and that the plaintiff or defendant was prevented by mistake, accident, or other reasonable cause from prosecuting the action or making the defense. So it basically means that, if you didn't participate in the case and a default judgment entered against you, you have 4 months in which to try to reopen the case. And it doesn't mandate that the case be reopened. The court ultimately has the discretion as to whether or not to reopen the case. Now, you may want to reopen the case based on some reason other than default or non-suit. So, some examples might be, you discovered new evidence that you want to present, and you're within that 4-month period. So in that situation, so going back to this, it's 52-212 is the opening judgment upon default or non-suit. And the relevant practice book section, which has a lot of the same language, is 17-43. And then this section's practice book section 17-4 is not necessarily due to default or non-suit, and the corresponding Connecticut general statute that goes with that, with this practice book section, is 52-212A. So again, the practice book section or the statute will have a lot of the same language as the practice book sections. So 17-4 of the Connecticut practice book says that unless otherwise provided by law, and except in such cases in which the court has continuing jurisdiction, any civil judgment or decree rendered in the Superior Court may not be opened or set aside unless a motion to open or set aside is filed within 4 months. So again, in most circumstances, in order to try to have a judgment reopened, you have to file it within 4 months. You might want to present new evidence, or you may have forgotten to make a certain argument, or maybe you forgot to present evidence. It wasn't necessarily new evidence. You just forgot to present it entirely. You can file the motion to open, and the court may or may not grant your motion to open or set aside the judgment. Now, there are circumstances in which you can reopen the judgment after that 4-month waiting period. And there's not a statute that dictates that. That is more dictated by case law. There's a number of appellate court cases, but we'll look at this one, Coopersmith v. Coopersmith. It's an appellate court case from 2013. And it says that a judgment rendered in an action for dissolution of marriage may be opened and it's not just dissolution of marriage. It could be a custody case or, any other kind of family law case. It may be opened after the 4-month limitation if it is shown that the judgment was obtained by fraud, in the absence of actual consent, or because of mutual mistake. So let's look at fraud. So obviously that's pretty self-explanatory. Let's say, you found out your spouse, said he had $200,000 in his retirement account, but you later learn that he had another retirement account that he didn't disclose that had an additional $1 million in it. That's an example of fraud, that in which case you can reopen the judgment, and you can do that at any time. It does not have to be within 4 months. Let's look at in the absence of actual consent. So an example of that would be, you sign an agreement. Sometimes you might sign an agreement for a divorce and like not show up to court. And, so you sign the agreement and it turns out that your spouse like changed the terms of the agreement without you knowing. Or let's say, you were incapacitated for some reason and you didn't have you were in a coma, or you were, in the hospital where you had brain damage, temporary brain damage or something like that. You don't have the ability to make actual consent in that situation. So you can reopen the judgment after 4 months if you did not have the ability to consent to the actual agreement. And then mutual mistake is another example, in which case you don't have to finalize or reopen the judgment within 4 months. An example of mutual mistake is, let's say you and your spouse, thought that he had $500,000 in his retirement account, and it turned out he had 1.5 million. Maybe it wasn't fraud because he didn't know. For some reason, he had no idea there was that extra million. But the two of you were under the impression that there was 500,000 when it was actually $1 million. So that is, the two of you were mutually mistaken. Both of you were mistaken about that provision. Therefore, you can reopen the judgment and try to get a different result based on that mutual mistake. A unilateral mistake is not basis for reopening a judgment after the 4 months. It has to be a mutual mistake that both of you were mistaken about something. So those are kind of the circumstances in which a judgment can be reopened. And let me just kind of show you the practicals of what a motion looks like and how the process works. So it's pretty basic, where you just put, plaintiff's or defendant's motion to open the judgment, and then you cite the practice book section or Connecticut general statute. You respectfully move the court to enter an order opening the judgment of dissolution by the court, or again, it might not be a dissolution, it might be a custody case, which was entered on, insert the date and the judge's name. And then you're going to want to, below that, obviously insert an explanation of why you think the judgment should be opened. So you're going to want to get into detail citing the practice book section or Connecticut general statutes that you just went over, unless it was mutual mistake, absence of consent or fraud, in which case you're going to want to cite the appellate court cases that allow you to reopen a judgment under those circumstances. So you put in that description, and then you put an order for hearing and notice at the end, because you will have to serve the opposing party with the motion. So those are the basics of the actual motion, and then just procedurally how it works. You file the motion, and then you are entitled to a hearing on your motion to open the judgment. So you would be scheduled for a hearing, and then you would make your argument as to why you want the judgment to be opened. The court doesn't, again, they don't have to grant your motion to open, but you are entitled to a hearing on your motion to open. So those are the basics on how to attempt to open a judgment in Connecticut. As usual, if you can, first of all, you can get the sample motion that I just showed you off of our website. And if you have any questions, feel free to give our office a call.